Thanks, Chair, and good to be with you this morning. And colleagues, just at the outset, thank you for the invitation. This is the first time I've been at the committee since I was appointed to this role, so I very look forward to working with the committee in the period ahead on the various challenges that the health system faces and that you and your colleagues will be engaged with us on. I'm joined, as you mentioned, by a number of my colleagues this morning, and I'd like at the outset to thank them for all their work they've done, particularly over the last 2 months in responding to these allegations. A very significant amount of time has been put in by colleagues who are here with me and other colleagues who aren't maybe this morning in responding to these allegations, and during a period when the department, as you're aware, is very busy dealing with issues in relation to the pandemic, the variety of issues that we're dealing with. And also, Chair, since it's my first time here as Secretary General of the department, I'd also just like to thank my colleagues more widely in the department for all their work over the last 16, 17 months or so, longer, in dealing with the challenges we face with COVID, the enormous contribution people have made and the enormous work and effort put in, I think really embodies what's great about the Irish Civil Service and the public service. So I'd like to thank colleagues. This is the first time I've been at this committee in this role. I've been invited to discuss matters arising from the allegations made in the RT Investigates broadcast. To begin with, I think it's important to highlight the context in which these allegations are made. The Minister for Health is named from time to time as defendant in litigation cases. This was a situation, a number of cases dating back to the early 90s, taken against the state. In approximately 230 of these cases, the Department of Health and the Department of Education are co-defendants, and 29 of these cases remain open. These could be either active or dormant, but they're open. That is, they haven't been settled either through mediation or through court settlements. As is the practice, both departments are jointly represented by the Chief State Solicitor's Office under the coordination of the Office of the Attorney General. The approach both departments, and long-standing approach of the Department of Education and the Department of Health students with special education health needs, is to seek to ensure the provision of the appropriate services to those students as best it can be. It is only where the suitability of such services contested that litigation ensues. And the department always seeks in the first instance to resolve proceedings on appropriate terms where possible. And for the majority of the concluded cases, these are resolved by the parties involved through mediation and not by the courts. And I think that's an important point to emphasise. As members of the committee will be aware, the allegations previously brought to the Department of Health's attention in February of last year through protected disclosure and were the subject of an independent review by a senior counsel. And this was completed November 2020 and was published 21st of April 2021. And I've shared a copy of the review for the committee. And just Chair, because you and I spoke about this, the reason we were delayed in sharing the copy with the committee was to ensure that the rights of the disclosure were protected and that consent had been received, and that we'd gone through all the necessary process to ensure that the rights of the disclosure were protected. You'll be aware that this review assessed an allegation of gathering and sharing of information regarding special education needs litigation related to correspondence and spreadsheets, and found there was no basis for a reasonable belief of wrongdoing, as this term is defined in the Protected Disclosures Act 2014. It also outlined that the information shared between the parties is consistent with and typical of the sort of information which arises in such litigation. And the report is very detailed, and it goes through the types of information that were provided by the whistleblower to the council, and it sets out the context and sets out conclusions and assessments on foot of the review. Following the RTE broadcast, and following the allegations in the RTE broadcast, I established a team in the Department of Health to establish the facts surrounding specific allegations made in the programme and related articles on the RTE website. The team was supported by 3 independent barristers who act as external documentary review counsel. This in effect involved going through files and establishing what was on those files, and to establish the extent to which the allegations that were made were true. And this report was also published on the 21st of April, and a copy has been made available to members of the committee. I will set out some important facts that have been established based on this independent review. Number one, the Department of Health has never gathered sensitive medical and educational information on children involved in court cases in the manner portrayed by RTE. Second, there is no evidence that the Department of Health was secretly compiling dossiers on children with autism involved in special education needs litigation as alleged by the RTE programme. As co-defendants in litigation cases, the Department of Health may have documents on file that form part of the proceedings. Such files contain information arising in the course of the proceedings, including the pleadings and correspondence received from all parties, including plaintiffs. And most of the information on files includes the information provided by plaintiffs in the course of their pleadings, setting out the case they wish to make and the basis upon which they're taking a case against the state. And I think there's been some misunderstanding about the nature of information that will be held. Most of the information is information that was provided by the plaintiffs or information provided in pursuit of their action by their legal representatives. There is no evidence that the Department of Health is prying on families, and I use the expression prying because that was the term that was used in the RTE programme. I'm not entirely sure what was meant by that, but I think it's generally meant in a pejorative way, suggesting something underhand or covert. And there's absolutely no evidence of this whatsoever. Fifth, there's no evidence the Department of Health gathered information that was beyond instructions as part of the normal defence of litigation case. So based on the review from the evidential barristers, and this was confirmed in the original review by Conal Brady, the information held on files was the type of information that you would expect to see in cases such as this. And I've had a chance to look through some of the summary information, and it's the type of information that you would expect to see: the name of the plaintiff, their legal representative, the case they're making, the status of the case, and so on, and accompanying documentation in the main, as I say, provided by the plaintiffs. There's no evidence the Department of Health sought updates or reports on plaintiffs directly from schools of the Department of Education. And 7, there's no evidence that the Department of Health sought clinical reports on plaintiffs directly from clinicians. There are issues around data protection, which the various papers identify, and we welcome the inquiry by the Data Protection Commission, which is currently investigating data collection practice in this area. And of course, the Department is cooperating with the Data Protection Commissioner and will gladly take on board any recommendations the Commission may have in respect of how we could do better in this area, if that is the conclusion and recommendations arising from the review. I know the headlines generated by the programme have caused distress for some of the families concerned. Accordingly, the Department of Health appointed an independent support liaison officer to engage directly with the 29 families involved in these allegations. And I have personally written to each of the families through their solicitor on file, offering an opportunity to engage with them. I have also endeavoured to keep in touch with stakeholder organisations. On April 1st, I provided an update via open letter and further on the 21st of April when the 2 reports were published, and I shared these with the organisations. I again underlined that their role representing many patients and families affected by autism is valued. I continue to be committed to engaging and informing them of updates regarding this issue as we go forward. The mission of the Department of Health and the mission of myself and my colleagues is to improve the health and well-being of people in Ireland. The core priority of the department over the past year has been the response to the COVID pandemic, the intense work in continuing to responding to the impact of the pandemic on our nation's health, and the service we deliver will continue long after societies reopened and the last vaccine has been administered. So I look forward, Chair, to our discussion today, and I want to assure you of our commitment to delivering on the department's priorities. In effect, the health and well-being of the people who use the health service is at the centre of all the decisions that we take within the department. So I'll stop there, Chair, if that's okay. I'm very happy to engage in any questions.
Okay, thanks very much, Mr. Watt. Our first question there is Senator Martin Conway.
Okay, thank you very much, Chairman. And in the first instance, I'd like to wish Mr. Watt all the very best in what is an extremely important job in the Irish healthcare, the provision of Irish healthcare, and hopefully it will work out okay. Just in terms of the primetime programme, did you have sight of the programme before it aired on the 25th of March?
No, we didn't, Senator.
Okay. I understand that you made a call to the Director General of RTE on the day of before the programme aired. You might just enlighten us as to what the purpose of that call was.
Yeah, so obviously the call was a private conversation, so I'm not in the practice of disclosing the contents of private conversations, but I did note that the conversation was reported in the papers, which was a bit of a surprise. But basically, Senator, the context was that Primetime Investigates had written to the department several weeks before the programme was broadcast, giving a broad indication of some of the things they were saying, not the full details, and didn't give us an opportunity, as far as I'm aware, to review the programme. But we were aware of the issues, and we were involved in correspondence with them, setting out our position. So we had some sense of the allegations that were made. And there were two things that we were both conscious of. First of all, that the allegations were extremely serious and would cause distress to families if those allegations are made publicly. And secondly, we didn't believe the allegations were true. So I wanted to ensure that the Director General of RTE, in her role, understood the gravity of the allegations, that these were as serious as it could be, to suggest that officials of a government department are prying on citizens or engaged in covert operation and secret dossiers and so on. This type of language, these type of allegations are serious. So I wanted to make sure that the Director General understood the seriousness of the allegations, which I think after the conversation she did. And secondly, I wanted to make it very clear that based on what I had seen and what had been brought to my attention, based on the whistleblower's report, which I understood that stage RTE had elements of it, if not all of it had elements of it, and it certainly had been briefed by the whistleblower himself, that I wanted to basically say to her that we didn't believe the allegations were correct, and I didn't think it was appropriate for RTE to make such serious allegations of that nature when in effect we didn't believe, and I set out why we didn't believe they were correct. So that, Senator, is the basic sense of the conversation.
Okay, just post the programme broadcast then, have you had subsequent discussions with the Director General or any other senior officials in RTE?
So not with the Director General, but I have spoken with other, around the time that week of the programme. I had a few conversations with John Williams. I think John is head of news and current affairs, but I haven't spoken to anybody in RTE about it since about the 22nd, 23rd of April. But our press people in our communications people in the Department of Health have spoken to RTE since about it. And obviously, Senator, we're reflecting on what we'll do now vis-a-vis the programme. Obviously, we haven't waived any of our rights to challenge the programme. We haven't waived our rights to make a formal complaint against RTE or take any other action, and all those things are still possibilities. We haven't had time to consider those, but we will, of course.
Are you aware of any subsequent programme that RTE may have wished to air or possibly considered airing but decided not to, or postpone?
Not that I'm aware of, no.
Okay, thank you. Now, just in terms of the Ombudsman, for the Children's Ombudsman, have you had any contact from the Children's Ombudsman subsequent to the programme being broadcast? Because I believe he had some harsh things to say in the aftermath of the programme. Yeah,
I think I think when allegations are made of the type that were made, I think departments are allowed, as I'm being allowed now today, the opportunity to respond to those allegations. I was disappointed that people came in and basically assumed the allegations were correct without accepting the bona fides of the department or without reading the material that had been made available. So I haven't spoken with Niall, I think it is, Niall Mundoon, but I've corresponded with them to say that a fairly standard letter, Senator, saying that, look, the allegations aren't correct and we don't accept the allegations, setting out the context. So I did correspond with them. I thought it was appropriate to do that.
Okay, just in terms of the representative bodies to the various clinicians, in terms of the whole issue of ethics, because I accept the fact that possibly no laws were broken, but certainly there is an ethical issue that people are grappling with. Have you had any engagement with the representative bodies of the various clinicians in terms of the whole ethical framework around what's happened?
I'm unsure, Senator, what particular ethical issues you're referring to, because there might be many. I'm not entirely sure, but I haven't, and I don't think we have correspondence with the representative bodies. But I'm aware there has been some commentary, but we haven't written to them, or we haven't spoken to them about it. Like I think the bodies made an initial reaction based on media reports, which I don't think reflected the reality of the situation. I think when those bodies, I presume the Medical Council, Senator, you're referring to in the main, I think with the Medical Council, when they have read the material, we might have a conversation with them actually when they've had a chance to review the material and heard what we said, and then we can have a conversation with them. And obviously, we welcome their views if they've got ethical concerns based on what we've heard. But of course, the main ethical concern, I guess, was the allegation that we had gone to the clinicians without the consent of parents and had directly sought clinicians' report. And there are various allegations that we had gone to private doctors, and there are various other. So obviously that's not true. So I think when that was the main ethical concern, I presume the Medical Council will be reassured when we set out the findings for them. Sure. But obviously that's for them to judge.
One of the key issues that Shane Core has had and outlined it to us last week at a private meeting is essentially that there would appear to be some class of a service level agreement or certainly established protocols between the Department of Health and the Department of Education in terms of sharing information. There's spreadsheets in existence and so on. What's your view on that? Is that correct? And is such protocols in existence? So
exactly, Senator, as you say, the fact that when a case is taken against a state, that there could be several co-defendants, and for purposes of administrative efficiency, more than anything else, the practice has been, and that has been confirmed as the correct practice over a long period, for the various information to be collated and shared. And it's really to ensure that, in the main, that we can progress the cases quickly and settle quickly or mediate quickly and get things run to the satisfaction of both parties. The state and including the plaintiff. So that's a long-standing practice, which is there, Senator. And I think it makes administrative sense. I think it is being confirmed to be lawful, and there are various issues around that. But it's the only practical way in which I can see us managing these cases effectively.
One of the other issues that Mr. Core has serious concerns about is that the department is preparing, essentially, in the possible event that there is cases taken on a human rights basis against the department. So essentially what you're doing is you're gathering the information and you have it ready to go if an action was to actually materialise. And he was more or less making the case that there is a serious ethical issue there. And of course, if that is happening, there is a serious ethical issue there.
Yeah, so thanks, Senator. Thanks for the question. So I'm not in a position, nor should I be in a position, to respond on any further allegation that the whistleblower made in a private session involving yourselves, because I wasn't invited to that private session, nor was the public invited to that private session by definition. If we had been invited to that session and I had heard what had been said, well, then I'd be in a position to help you in responding to those. And I don't think it's appropriate for me to be asked about further allegations that have been made in a private session when we weren't privy to those.
I'll put it another way to you. So, is there a section within the department that's essentially managing risk? That is identifying if there is potential litigation that may arise down the track, and that are preparing and putting together a dossier of information on the basis that there is a potential legal risk to the department?
No, absolutely not, Senator. And I just wanted to make the point here, and this is for the Chair, I am not going to respond this morning to allegations that are being made at a private session to which I was not invited, nor my colleagues were invited. It'd be totally inappropriate and not consistent with anything approximating to fair procedure. If you wanted us to be party to the discussion you had with the whistleblower last week, you should have invited us to the meeting, and you didn't. So I'm not saying, Senator, that's all. I'm not criticising you now, but I can't be expected to respond to allegations.
I put the question in a different way, which I think you responded to.
Yeah.
I put the question that is there a section within your department, or is there a package within your computer system that's storing and preparing information for potential legal challenges? And you're quite clear that that's not the case.
No, that's not the case. But I just want to say, I'm not.
I'm just conscious of my time, Mr. Watt.
No, absolutely. I'm aware of that, Senator. I know that I can confirm that no is the answer. But like, if there are further allegations that were made last week, if they're going to be repeated at this committee now, we need to see written evidence of those allegations before they're going to be repeated again. I think it'd be absolutely, totally inappropriate, and I'm not going to respond to any allegations that are made last week.
You've said that 3 times, Mr. Watt. Yeah. You only needed to say it once. Well, so, Chairman, you might give me a bit of latitude for my question.
Sorry, Senator. I just wanted to make that clear because it's a very important point.
Yeah, well, you've done 3 times now, and you're not going to talk down the clock with me. Just in terms of the liaison officer that you've appointed for the 29 families, you might actually give us an update on how that work is proceeding. I know that person was appointed, I think, the end of last month. Can you give us a quick initial update on how that person is getting on? Have the families responded positively to the engagement?
Yeah, so I don't have all the details on that, Senator, but yeah, I believe that the liaison officer has made contact with families through their solicitor, and that there's some engagement, and there are various requests to look at the data that we have, and there's various engagements to explain the process and how we can help families to reassure them about the information that we may have in respect of their cases. So I can follow up, Senator, with a more detailed note. I don't have all the details to hand, unless one of my colleagues might have more to say.
Just before you go, just finally, I'm sure you can understand how horrified people in general with special needs and people who have children who have special educational needs were to the broadcast of that programme. And, as somebody myself who had special educational needs when I was a child, I certainly would be very concerned at any breaches of what would be considered standard ethics in terms of the Department of Health and Education sharing information. Have you reviewed the manner in which you do share information in light of what was spoken about on that programme?
Yeah, so we would share, Senator, your concerns absolutely fully, and we would be as concerned as you would be or anybody else to hear those allegations. And ethical issues, like there were more than ethical issues raised. There was much more fundamental issues raised than that. But issues of an ethical nature, of course, we're concerned, and we will review our practices, and we will review how we share data and our overall approach in light of what was said. My colleague Kathleen wants to come in just to add, Senator, to what you, Kathleen.
It might be useful just to clarify that in the context of this litigation, the Department of Education is a co-defendant, and it is normal practice with co-defendants that information would be shared. And it's also important to clarify that the management of these litigation cases is supported through the Chief State Solicitor's Office and directed through the Attorney General's Office. So information provided to the Chief State Solicitor's Office is generally copied to the other co-defendant, and that will be how information in relation to education would be on the files. And it has been confirmed to us that there is no wrongdoing in this, that this is absolutely within the context of the data protection and the GDPR articles.
Okay, final question to Mr. Watt then. Another concern is that a lot of people had access to this information. Can you give us an idea of how many people would have access within the department to these sensitive files? Is it possible that a tech-savvy clerical officer in a different section would be able to dial in and review and read these sensitive files?
So thanks, Senator. So there are 25 people who are in the security group who could access the files. And since these allegations were made last year, we have tightened up on our procedures, and we have put in further protections in relation to the files, more password protection, more encryption, and so on. But 25 was, I believe, the number of people who originally.
But prior to you putting in these new encryptions and passwords, was there the potential for a lot more people to have had access to those files?
No.
No. Like there's always, like any system, Senator, as you know, no system is absolutely 100% secure, as we know. But there were the people who had access to those files were part of a group of people who were given clearance and were aware of their obligations, were aware of their obligation to data protection.
On foot of the programme, did you bring in an independent security firm to review your security systems within the computer operation that you have, just to be sure that practically everyone in the department didn't have access? Did you get any independent advice on that?
Yeah, just to clarify, Senator, not everybody in the department could have accessed the files. Only 25 people could access them. They're part of a secure.
Then why did you need to introduce extra encryptions and passwords if that's the case?
Because we wanted to add, when the issues came to light, we reviewed it. The department reviewed it, and there was further measures that could be taken. And those measures were implemented.
Martin, you've gone over time.
I'll finish now, Chairman. My point is, if the system was as foolproof as you said it was, why did you need to introduce extra IT security systems?
No, I didn't say, Senator. I'm sorry, I may have misspoke there. I said no system is foolproof. Yeah. When these issues came to light last year as part of the review, the department then put in extra security features. And the acting SecGen of the department at the time, Dr. Colin Burke, emailed around colleagues, reminding them again about data protection issues, about their obligations not to access files unless they need to, about the need to be responsible. And their guidelines, their sort of ways of working that people accept in government departments. There can be sensitive information, and people are very conscious that they shouldn't access information they're not entitled to access. They shouldn't share it, and so on. But it's a fair point, though. Like there's always a need to review and to look at security around data management, and that's something that we take seriously. And on foot of this, the Data Protection Commissioner is in now doing review, and we're very happy to work with the DPC on that, and look forward to any recommendations they have.
Thank you, Chairman. Thank you, Mr. Watt.
Thanks, Senator. Thank you.
Our next questioner is David Cullinan.
Thank you. Can you hear me, Mr. Watt?
Yes, we can.
Deputy, yeah.
Perfect. I just want to address the Cathaoirleach first, and can I say that it is up to the committee itself and to the members of the committee to determine our business and to determine how we interact with witnesses. And we sought legal advice in relation to our engagement with the whistleblower, precisely because we want a due process. So I would say to the witness to be less defensive in relation to that. And also, we have no interest in whatever future complaints may or may not be made against RTE by the department are not our business. And our business is to get down to the issues which were brought to our attention as a consequence of this programme. So I say that to the Cathaoirleach, first of all, Mr. Watt, and not directly to yourself. So I want to get straight to your opening statement. And you say in your opening statement that the Department of Health has never gathered sensitive medical and educational information on children involved in court cases in the manner portrayed by RTE. So first of all, what do you mean by the manner portrayed by RTE?
So the programme suggested that we were seeking information, going out seeking information from clinicians, from medical practitioners, on people with needs without the consent of parents, and that was part of a covert campaign of secretly compiling dossiers and prying on individuals. So that's
let me get to some of those allegations, and then let me just not put it to the test, but let's just see what information is held by the department in relation to all of these cases. So you say in your opening statement that there was 230 cases where the Department of Health and the Department of Education are co-defendants. How many cases are there in total? You talk about this going back to the 1990s. So do you have the figure of how many are in total? Maybe were ones where the Department of Health were the only defendants. What's the total number, first of all?
I think 230 is the total number of cases.
It is the total number.
Deputy, yeah, that's fine. That's fine. Yeah.
So when you say then that the department were not gathering sensitive medical and educational information, Was there any information from private doctor consultations in any of those 230 cases held on a file anywhere by the department? That was not provided by the plaintiff.
Sensitive. So from private doctors, not that we're aware of. No, not based on the review that we've done. No. So
there was no private doctor consultations, or no information from any private doctor consultations in any of the cases. The information provided for the plaintiffs might involve consultations with so information that plaintiffs provide as part of their pleadings, as part of their proceedings, and I guess there could be. But what you're telling the committee today, so what you're telling the committee today, Mr. Watt, is that there is no information that was provided through that private doctor consultations in any of these cases that were not provided by the plaintiff. You're saying absolutely not.
So what I'm saying is that there was no information sought from private.
No, I'm not asking about whether it was sought. I'm asking about whether the information is held, whether it was on any of these files. So whether you sought it directly or indirectly, it's whether or not you had the information. So again, I'll ask the question directly. Forgive me now, Mr. Watt, I'm putting the question. What I asked you was not whether you sought it, whether it is being held, whether it was on file. So again, I'll put the question very directly to you because we have our information as well. Was there any private doctor consultations or information flowing from any of those private doctor consultations in any of the cases that was held that did not come directly from the plaintiff? It's a yes or no answer.
Oh, no. Like that came. So the information in the main came from reports would come from the plaintiffs, but you say you have other information to dispute that. What other information, Deputy, are you referring to?
Well, I'm talking about the information that we would have got from the whistleblowers and the information that was in the primetime programs. What I'm saying is that we're putting this to the test. So you're saying that there was no cases at all where there was information provided from private doctor consultations. I'm just asking you the question. You've answered the question. You're saying there isn't any information. That's fine. So
my colleague Kathleen wants to come in, yeah?
Oh, no, I'm putting my questions to you, Mr. Watt, because I have other questions as well. If you're saying that there isn't any, then we'll take it there isn't any. And I'm going to move on to my next one. The next one is in relation
Sorry, Deputy. One of my colleagues here wants to come in and add to what I've said. I think that's allowed, isn't it?
Let Dr. McClelland in, please.
Thanks very much. I think it's important to clarify that 3 external independent documentary counsel went through the 29 files that have been held in relation to the department, those open files that were referred to on the primetime programme. They went through the provenance of the information that was on those files, and it is clear that there is medical information there, but that medical information has been obtained through the plaintiff or provided as part of the pleadings from plaintiffs. We did, as we have outlined in the Secretary-General's fact-finding report, find that there is one case fairly recently. It has been publicised, obviously, on the primetime programme, where inadvertently some clinical information was provided by an individual clinician, and that was held on a file. And that going back to files in the 1990s, so around 30 years.
Can I just stop you there? So what you're telling me then is there is at least one case of where information from a private doctor consultation was held on.
I didn't say it was from a private doctor. This was information that was provided through the HSE, who's a co-defendant in the case.
Yes, but where did the HSE get the information?
This is the email chain that has been referred to in the
but where did the HSE
report.
get the? I'm asking where the HSE got the information.
So we have outlined in the Secretary-General's report that there was an individual clinician got directly in touch with the department and provided clinical information, and this information was not information that the department had sought from, and that this clinician is a clinician.
This is not the question that I asked. I didn't ask whether it was sought. So if I want to understand the process here, so what you're saying is that an individual clinician gave the information to the HSE, who then gave the information to the department.
No,
and that
a HSE clinician. A HSE clinician. So this is the HSE who's a co-defendant in these cases, and this is, as we have outlined, this email chain within the fact-finding report that the Secretary-General has.
Can I ask, was there any sensitive medical or educational information on children in any of these files, or in any way held by the department? Mr. Watt?
Yes, there is information that could be deemed sensitive. Yes, information provided by the plaintiff as part of their case.
And would the parents of those children be aware of the exact nature of all of that sensitive information in all cases?
The information was provided by the plaintiffs in most of the cases that we've looked at.
In all cases I'm talking about. So the question I asked wasn't most cases. What I'm asking is, in all cases, was any sensitive or medical or educational information that the department had on, whether you want to call it a file or whatever way you want to characterise it, was there any information that did not come from the plaintiff that the plaintiff would not have been aware of?
So apart from the one case that Kathleen has mentioned, which is well documented in both the reports, no. Most of the information, as I said, came from the plaintiff or came from service updates which were provided by the HSE manager or the manager.
And those service updates that came, this is what I'm getting at, Mr. Watt, because those service updates came from the HSE, and those service updates, what I'm asking is, in any of those service updates, did that contain sensitive medical and educational information?
No, in the main it provides an update, Deputy, and I think this is something which hopefully we can share, if we haven't, we can share examples of what it is. So basically this is an update provided by, in effect, the case manager in the HSE, who would be providing services for people to say that person is receiving this type of service, that type of services, and a view about, their satisfaction, the family's satisfaction, or an assessment about whether that service is in line with what was agreed to that the person would receive. So it's fairly factual information.
And you're telling me that in all cases, in terms of all of that information that came from service providers or through the HSE, that in all cases that would have been information the plaintiff would have been aware of. So there is no information of any sensitive nature, medical or educational or otherwise, that is on any of these files that the plaintiffs and the families would not have been aware of.
No, I'm not saying that, Deputy. So the service updates were information provided by the manager, the HSE manager.
I understand, that's my point.
The case manager.
My point, and I'm saying that in that information.
Yeah, and that information is updated regularly with a view to settling the cases, with a view to actually finalising the cases, and that's where the email exchange with Kathleen just mentioned there.
That's the whole point, Mr. Watt, because there is a perception from the families that this was again the state pushing back against its weakest citizens and trying to force families into settling cases because of the nature of the information that was being compiled and being stored. So when you say that service updates were given, what I'm asking you is that in all of the cases, including in cases where maybe information came not directly from the plaintiffs, are the families aware of all of the information that was held or stored by the department in relation to all of that information? And was any of that information, sensitive information, medical or educational or otherwise, held by the department that families would not have been aware of?
So there's a number of dimensions to your question. Like you said, are people forced? No, nobody is forced to settle a case. Every party has the opportunity to settle the case or not settle the case. The service updates were an attempt to bring to finality cases that had been not closed and were dormant. And the whole point of the service updates was that the co-defendants, the HSE, the Department of Health, the Department of Education, was to find an update on what was happening with the level of services being provided. The information.
I understand this, Mr. Wall. I understand all of that. You've made that point. You've made that point in your opening statement. What about school reports? Where did the school reports come from?
Yeah, Kathleen may wish to address that.
Just to say that any educational information that's on the files is information that has been provided or copied to the department as part of the information that the Department of Education was providing through or from the Chief State Solicitor's Office. The Department of Health, in the review that the Documentary Council did, the Department of Health did not contact schools or educational institutions in relation to receipt of information. So this is information that the Department of Education would either have sought or received as part of the cases.
And can I ask Mr. Watt, and we see the problem is parents will be looking at the totality of this and looking at the totality of information which was being held. And some of it may have come from the plaintiffs and some of it did not. And I think that's why we need full open disclosure and we need to have a review of policy here. Because Mr. Watt, you were talking about this being standard practice. And people are reasonably asking the question, whatever about the legality of it, is it right that this is standard practice? And is it right whether directly or indirectly through service updates or otherwise, that information of this nature, of a very sensitive nature in some cases, and including, by the way, and I'll ask this question now, potentially confidential information that provided an insight into the mental state and well-being of the children and their families, and issues in relation to very sensitive information that were happening in families itself. That obviously does trouble people, and it obviously does concern people. And the question is whether or not there was full open disclosure with the families involved. And I'm not satisfied that there was. So what I'm saying is that today as we speak, any information that has been held on any of those families, in all of those cases, has that now been fully disclosed to the families?
So the families, a number of families have put in data requests, and we're complying with that, and we're very happy to do that.
Have you proactively done it, Mr. Watt? You don't need to wait. What I'm saying is, have you contacted all families and said, here's the information that we have on your family, and broadly here are the areas, and if you want more information, we will provide it. Surely there's an obligation on you to do that.
Yeah, so we contacted the families through the liaison officer, and we're engaging with them on that. Deputy, there's a suggestion here, and this is, I think, the premise of your question, that there's something untoward here, or underhand, or inappropriate going on here. There's not. Okay, there really isn't.
Well,
Okay,
we can differ on that, Mr.
David,
Watt.
you need to come to an
You
end.
can have your view. My view is that there is a difficulty here with some of the information which is on file, and some of the information which is of a very serious medical and sensitive medical and educational information that were being held on children, that was being collected in some instances without, in my view, without the knowledge of the parents involved.
Deputy, you're now repeating, and I don't want to get into an argument here, you're now repeating once again allegations which are not true, okay, and which we've comprehensively addressed is not true. We've set out over 100 pages of documents which set out the position here, and what you said is just not true. Okay.
I need to move on, David.
No, if I finish on this here, look, I'm not interested in, nor have I sought to get into issues in relation to data protection or even the legalities of all of this, because other people will make those judgments. I'm looking here at the process and what your department has said was standard practice. And I'm looking at the type of information which was held, some of which came through service providers. Some of the information was not known to the families involved. And these were families who, by the way, Mr. Watt, were simply trying to get their children the resources that they need, trying to get their children the support that they need. They shouldn't have had to take the state to court at all. And I see this as inappropriate, that in the first instance they felt that they had to go to court. But then in cases that were not settled, that information was coming from service providers, from the HSE, because what you say, in a lot of semantics in your opening statement as well, where you say we didn't directly seek information. Whether you directly sought it or not, if you had it, and you got it from third parties, you got it from service providers, you got it from wherever you got it from, and it was held on files, and the families were not aware of that, that does trouble me. It may not trouble you, but it troubles me.
You need to finish, David.
No, Deputy, if your characterisation of what was happening here was correct, it would trouble us. Of course it would, but it's not correct what you've characterised. Again, it isn't correct. And you said you have other information there. If you have other information, please provide us with the information. I think Kathleen wants to come in. Kathleen?
I think it's important to say that the Department of Health's first role is to provide services, policy and legislation for the health system. We have provided 2.2 billion for specialist disability services, a increase of 100 million this year. Nobody wants to see families taking cases in relation to access for services. And our role here is to try and build the actual capacity within the system so that the services that families are requiring can be provided. At the outset, and it's very clear in the documentation that's been provided, that the first principle for both the Department of Education and the health system has been to provide services for these families, and in the case where we can't actually meet what families are after, that we would work with them over the years to try and sort out the service issues and to try and resolve those. And secondly, that the principle behind the legal approach was to try and settle these cases, not to have these cases continuing. The department is very sensitive to these families and where they're at and the services that they're trying to provide. And that has been our approach over a number of years within the department, is to build the specialist disability services so that the services are in place for those families.
And I don't doubt, if I can make one final point.
No, you're over time, David.
I don't doubt that investments have been made. But if you read any of the statements which have come from all of the advocacy groups, representing parents and representing children with autism.
You're way over time, David.
They say differently, that there is a real challenge in accessing services in early intervention, and that in part in the early 90s and since has led, unfortunately, to parents having to take the state to court. And that's not where they should be.
Okay.
And I think
you need to
I'm not
finish.
satisfied, I have to say, with some of the answers I've got from Mr. Watt, and nor am I happy with, I think, some of the semantical.
Okay, you need to finish. Thank you. John Lahart is next.
Okay, can you hear me, Chairman?
Yep.
I wonder if you could. I have 10 minutes, have I?
Yes, I have. Yeah.
If you could maybe flag with 2 minutes left. I don't have my timer with me. Secretary General, you're welcome. I want to acknowledge your appointment. There's a heavy burden of responsibility on your shoulders, and I also want to acknowledge your willingness to come before the committee from the start. I'm a Deputy Secretary General, a second-term Deputy.
Sorry, I couldn't see you there.
All right.
Sorry, it's not a great format to have any engagement. Sorry,
no,
as you're aware.
And I also want to acknowledge that you're 2 months in the position of Secretary General of Health, and what we're discussing didn't happen in your tenure, and I think that has to be acknowledged. If we could agree, you weren't given an awful lot of time to answer in the previous session, so if we can agree, my questions won't take more than a minute, but I'll have to just put a minute limit on your answers, if that's okay, because of the format. What was the purpose of your I suppose, what was perceived as a public intervention in calling RTE in relation to the primetime documentary? Yeah,
thanks, Deputy. So, I spoke about this in relation to Senator Conway's questions earlier. So basically, there are two reasons to ensure that RTE understood the profound nature of the allegations, that there are serious allegations that they have been making, firstly, and secondly, to confirm to them that these weren't true, and that the evidence that we had and the information we had that these allegations weren't backed up, and we didn't think there was enough basis to go with the very serious allegations they were making. Okay. So they're the 2 points that I made to
Were you or any of the state agencies offered any opportunity by RTE to appear on the documentary or rebut or offer
No.
No. So RTE didn't offer the Department of Health or the HSE or any other state agency who might have been named or involved any opportunity on the Primetime Investigates programme to offer a counterbalance or to offer not an alternative view, but to offer a view?
No.
Okay. Just in relation to, this might clarify a thing, in relation to points 4, 5, 6 and 7 in your contribution. So there's no evidence that the Department of Health is prying on families. Okay, I'll leave that one out. Point 5, there's no evidence that the Department of Health gathered information that was beyond instructions as part of the normal defence of a litigation case. Is there any evidence that the state, through any of its agencies, did?
No.
Point 6, there's no evidence that the Department of Health sought updates or reports on plaintiffs directly from schools or the Department of Education. Is there any evidence that the state, through any of its agencies, did?
I think maybe Kathleen, we answered that question before in relation to the reports came from plaintiffs in the main.
Okay, but in the main, but is there any evidence that the state, through any of its agencies, sought updates or reports on plaintiffs directly from schools or the Department of Education?
In relation to, maybe if I just come in here, just in relation to the Department of Health and the HSE, we have no evidence that we sought those updates from schools. I can't answer for other departments. Okay.
And point 7, there's no evidence that the department sought clinical reports on plaintiffs directly from clinicians. Is there any evidence that the state or any of its agencies sought clinical reports on plaintiffs directly from clinicians?
No.
Okay. Just, is there a point in your experience as Secretary General or in any of the other witnesses' experience where, having gathered, I'm using the language loosely, gathered evidence in relation to a case that was ongoing, that the evidence coming in was so compelling on the plaintiff's side, as a result of that harvesting of information, and I use that term harvesting loosely, not in the GDPR section, that the state would decide, here guys, it's time to throw the hands up here. The case is so compelling. It's just there isn't a case for the state to fight. Actually, the plaintiff, as a result of this investigation, as a result of the evidence that we've sought from different agencies, is so compelling that the state must concede.
Yes.
Could you give an example? Would that have that applied to special needs cases?
Yes, I think so. Yeah.
I mean, obviously, yeah. I mean, I think it's not possible to talk about individual cases,
Sure.
but I mean, as has been outlined in the Secretary General's report, the overall strategy has been to settle cases where they can be settled, and where that's appropriate to settle them. So, like the state has clearly been trying to either provide, and it states that very clearly here, to provide the services or the educational or the health services, or to try and settle those cases so that those families don't have to continue with the litigation. And that has been very clear from the outset, and that has been the advice that the department has received all along, and the Department of Education.
And just to add, Deputy, to what Kathleen has said, so in the overwhelming number of cases here, these cases are settled through mediation, so they don't go to court. They are settled. I think the very small number go to court. I think 2 of the total went to court, and there's still some outstanding that we had been trying to, over the last number of years, to try settle. So the state in effect receives the pleadings, which, as you know, is about service delivery and the adequacy of service delivery and the suitability of service delivery, and reaches a judgment as to the merits of the case, and tries in the main to obviously improve the service or to engage the family or to settle the case. And that is the reality in the vast majority of these. And the process of the information being shared from different sources from the plaintiffs and is with a view to settling these cases.
Just come back to point 6 in your contribution. There's no evidence that the Department of Health sought updates or reports on plaintiffs directly from schools or the Department of Education, and you've answered that when I said, look, is there any evidence that the state or its agencies did? So I think that we should note your response to that. There may be other players who other committees may wish to invite to contribute on this. You say that the vast majority of evidence was provided by plaintiffs. Can you give us a little insight into how that evidence was provided, how it was elicited, and how it was provided?
So my colleagues, Deputy, can come in as well on this. So the Chief State Solicitor's Office would be the overall agency of the state that managed litigation for the state. So an individual, through their legal representatives in the main, would send in saying that they're suing the state in respect of the situation, and that documentation would be provided then, or to support their pleadings, documentations would be sought, and that information is provided. So that's in the main, and most of the documents relate to these information provided by the parties themselves.
Are there any cases, I know it's outside your remit, I have 2 minutes left, any cases then would say in which plaintiffs would have gone to their local school, for example, would say a parent, and said, look, I need all the reports on my child over the last year, school reports, exam reports, psychologist reports, speech and language therapist reports, or whatever. I need them in order to mount my case against the department.
Yes, I presume that will be. Kathleen, could you add to that?
Yeah, I mean, I just actually wanted to go back to the previous question where you asked about things on file. Like, one of the allegations made was that the Department of Health was holding video recordings of children with disabilities. And very clearly, when the Documentary Council went through those 29 files, there was a single video recording, but that actually had been provided by the plaintiff. It was not something that the department sought.
Okay, thank you for that. 2 final questions. One is in relation to just the whistleblower. What protections are in place in the department for the whistleblower? It must be quite an isolating position for the whistleblower to be in.
There are the protections that are provided within the legislation, Deputy, which are quite extensive and important, and we take our responsibilities very seriously. And if you go through, which I'm sure you've had an opportunity to go through the report, Colin Bradley's report. So when these allegations were brought to our attention, we went through the process as set out under the legislation and the guidelines in the civil service. So there are protections there for the individual. That's the purpose of the protective disclosure legislation.
And final question, thanks, Chair. So before your tenure, which is just 2 months old at this stage, there was a suggestion on the primetime programme that the whistleblower had brought this to the attention of your predecessor. And are you satisfied that the steps taken by your predecessor pass muster, that they met all the standards, that the relevant queries were made, and that the summation they came to was a summation you would have come to? And the final one is,
John,
to all the parents of children with autism, what would you say as a result of this, who have to fight tooth and nail for services? What would you say to that? And thanks, Secretary General and the other witnesses.
Thanks, Deputy. So yeah, the process was very professionally undertaken. The way it was set up, the commissioning of an independent review. The review is very, very detailed review, very, very comprehensive, and the steps then that were taken in terms of protecting the rights of the whistleblower, the disclosure, I think were absolutely what you would expect from a government department, and was done exemplary. What I would say to parents of people with autism and other needs is that the department is focused on doing all we can with HSE, the Department of Education, other state bodies to provide the necessary supports to ensure that people have the supports to meet their potential and to the best they can. And that's the main motivation of the department. And there are many of my colleagues involved in this who have spent much of their career in this space, working with providers, working with families, trying to provide the best possible services. And as Kathleen mentioned earlier, very significant resources have been devoted to this area and increases. So what I would say to families is that the system is doing all it can. And of course, there's always more to do, Deputy, because we're never going to be in a position where we have all the resources to meet all.
What would you say to RTE?
Thank you, David.
What I would say to RTE, I don't wish to get into that about what RTE need to reach their own conclusions on their report, and maybe they need to defend their report based on the evidence that's been out there. They haven't, since we published these reports, made any comment that I'm aware of. They haven't produced any evidence to support their allegations. The allegations are the most serious nature, and of the 7 that we've set out there, and there are subsets of that, RTE haven't provided any information, additional information that would corroborate or provide support for the allegations they made. And serious allegations, the notion that government department officials in a government department are prying on families. So it's up to RTE to reflect upon the programme when they've read the reports.
Thank you.
Thanks, Secretary General. Thanks, Chair.
Roisin, you're next. Look, we're running out of time. Every member so far has gone way over the time, so it just means that other members now probably won't get in at the end. So I'd ask you, Roisin, and your people that follow through, that if you can stick to the time, or maybe even shorten your time if you can. Thank you.
Well, I won't be shortening my time, Chair. Thanks, Mr. Watt, and you're very welcome. I'd just like to make the point at the outset that it's very unsatisfactory that we haven't got responses to requests for information from both yourself and the Minister. And there's a lot of information outstanding, and I think it is the likelihood that we will be asking you to return when we have that information and those responses in our possession.
Can I just say, Deputy, in relation to that? So we have prepared we a report which was commissioned, which I think is 40 pages.
Mr. Watt, if you don't mind, my time is very limited. I know what you sent us, and I also know that there's a lot of outstanding
I understand that, but you sent us...
I'm just making that point. I'm making the point that I think the likelihood is that we will be asking you to return, and I'm just leaving. I'm just leaving it at that.
But you sent over a request on Thursday evening.
Sorry, I'm not getting into the detail of that. I'm just saying that there is outstanding information, and we will be returning to this. That's the only point I'm making. Could I start then with your opening statement? And you make 7 categorical statements, 7 points. I'm interested in point 6 and 7. where you say there's no evidence that the Department of Health sought updates or reports on plaintiffs directly from schools or the Department of Education, and then there's no evidence that the department sought clinical reports on plaintiffs directly from clinicians. Would both of those statements be true if they said directly or indirectly?
Yes, I think they would be. Yeah, like in relation to the clinician, we didn't go to seek updates indirectly from clinicians. So we didn't, as part of the service updates, ask for somebody to get information which might indirectly be sought from clinicians. So I think yes, I think probably, but the allegation was very specific, Deputy. It said that we went. Okay,
no, I'm just asking you about your statement, because I don't think people would expect that the Department of Health would be going directly to a clinician asking for information. I mean, the steps along the way, HSE, local area manager, and so on. So I'm just asking, you're saying that those two statements would be true if the word indirectly was in there as well?
Yes, I think so. Yeah, we didn't.
Okay.
We didn't seek clinical reports. We sought service updates from the HSE manager. And there was no need for the HSE manager then to seek directly or indirectly clinical updates based on that.
Sorry, Deputy, I might just clarify on that as well. I mean, if you have a look at the report that the department published on page 14, it sets out the nature of the updates requested.
Thank you. I'm just very short of time, and I'm just want to ask.
But I think that answers your question.
Accurate to say that you didn't seek information indirectly.
And I think, as I said, that report clarifies the position in relation to that.
I'm asking Mr. Watt about the statement he's making this morning. Are you saying it would be true to say you didn't seek information indirectly?
Yeah, I think that's true, yeah.
Okay. So look, the allegations made on the programme, the whistleblower talked about an email seeking information and explaining to a doctor that the department was involved in litigation with one of our patients and asking for information. Okay, and we're told that was part of a template letter that was issued to HSE doctors, which explicitly asked that neither the family nor their solicitors are contacted about the request. Is that true?
So the report is the report. Yeah, it sets out the template. What's information is sought. Yeah.
Okay. So why do you have a template letter going to doctors?
Because the HSE managers, not to doctors.
Sorry. Well,
HSE managers in the.
Yeah. Okay.
Because HSE managers. Yeah.
Saying explicitly that neither the family nor the solicitors are contacted, asking that neither the family nor the solicitors be contacted about the request.
Because it's saying, and this is again, this probably should have been worded more. It could have been worded better than it is. So in effect, what we're saying here is we're not asking you to go to the plaintiffs. We're not asking you to go to their clinician. We're asking for an update from the manager. So it's not as was misinterpreted perhaps by RTE, an attempt to seek information without the consent of parents. It's actually purporting to say.
Okay.
Don't ask the information. If you need consent, don't go there. That's what it says. It should be better worded, which we accept.
Well, yeah, but the core of it is that you're asking a HSE manager for a service update, knowing that information will have to be requested from a doctor or a therapist.
No, that's not what the service update is seeking. The service update is seeking an update from the case manager, the HSE case manager. And maybe, Deputy, when we have a chance to share the types of information, now we can't obviously share confidential files on individuals, but we might be able to show you a template of exactly what is included in that service update, which is basically saying that these are the types of services that the individual is receiving and so on. It's not as been suggested by others. This is a very clear, and I've had a chance to look at them. This is a service update, which is very factual information about the types of services.
A minute left, Roisin.
Okay. Sorry?
You have a minute left.
Okay. Well, sorry, we'd like more information on that, because it's hard to know how a case manager would have that access to that information without contacting a therapist or a doctor directly. So look, I want to just ask you finally then, look, I'm concerned about the dormant cases. A lot of the points you make are points that are valid in relation to cases that are live. Why was it that you were putting all of this time and energy into cases that were dormant? Many of them, you know, there'd been no movement on them since 2005. Why was it in recent years that there was a flurry of activity on these dormant cases? What was the purpose of that?
The purpose was to try reach a situation where we could close the cases and settle and have a situation where the parties were satisfied and to bring the matter to an end. And the motivation was motivated by the best intentions to try bring these matters to
others will decide that. But what was the intention?
Sorry, I don't understand.
I'm just saying that others will decide that, and we will make up our own mind, as the public will too. So,
what other conclusion could you draw, though, from the work?
My question is this: what was the intention of the department in relation to costs?
Sorry, Deputy, in relation to costs in respect of
dormant cases.
In terms of whether the costs, who would bear the costs of the cases? Mm-hmm. The legal costs involved.
Yes.
I don't know. I think there are settlements here which involve monetary settlement, and I'm sure they encompass.
I'm talking about.
I'm sure they encompass costs.
Roisin, you're over the time, please. I need to move on to the next question.
I don't have the details of that, but I'm sure in the case of settlements, obviously matters of cost will be addressed normally when cases are settled.
But it wasn't with the intention of settling, was it?
Thank you.
The intention was to close.
The intention was to close the case through settlement, to mediate a conclusion to the case. That was the motivation behind activating the case that had been drawn.
Again, thank you. Nessa Horrigan is next. Again,
I'll do my best. I'll stay.
Okay, thanks very much.
So I suppose what I would like to concentrate on, because lots of things have been covered by other deputies, is the due diligence that the department would have undertaken around the legality of this. And we've talked about, RTE, but obviously this was a conversation that was happening in the department itself. So I'm trying to understand how we got to the place of commissioning the senior counsel's report in terms of was there internal legal advice sought, then external, and then the commissioning of the senior. Could you just outline that in as quick a timeline as you can for me?
So under the protected disclosures legislation, so if there is sufficient evidence to justify a review, well then a review is commissioned by the department, and that review will be an external review. So there are different stages to go through, and the department concluded last year that there are many allegations made, serious allegations, and that it'd be best if an independent barrister, senior counsel, was asked to come in to review, and that was done.
So the questions raised by that were significant enough to necessitate a senior counsel's report?
Yes, given the nature of protected disclosures, if the department considers that a review is warranted and there's evidence of a review, well then the review is undertaken, and previous Secretary General Breslin and others concluded, I think that was the right conclusion, to do that. And that report was commissioned, which is very detailed, and went through all the allegations and found that there was no basis behind the allegations. There was no evidence of wrongdoing in respect of any of the allegations, of which there are many.
Did the department ever seek legal advice of an expert in data collection, or seek a senior counsel who had an expertise in that area?
Last year, when the report was being compiled, in relation to so that the senior counsel is somebody who has knowledge in this area, and he was asked to do the job based on his expertise and knowledge, and obviously he's a knowledge of the law, including law in relation to data protection. I don't know if Kathleen wishes to add.
I don't want to go through the resume of the senior counsel, because I think that's kind of unfair. He's not here. I have actually done that, and that's not listed as one of his expertise.
I think it might be useful just to say that, like, all of these cases are guided by the Chief State Solicitor's Office and the Attorney General's Office, and at particular points in time, legal advice is provided to the department. And as was raised in the Senior Counsel, there was one recommendation that the department would check that particular legal advice had been sought in relation to data protection. The department did look at that. It did find that advice that was provided by the Attorney General's Office, and it did confirm that the department could rely on the legal advice that it had in relation to data protection.
Okay, well, that touches on my next question then. So the advice sought from the Attorney General's Office, was that sought once? That was one set of review that the Attorney General did for the department, or was it an ongoing dialogue?
The advices that come from the Chief State Solicitor's Office and the Attorney General's are continuous in relation to these cases, because the Solicitor for the State is managing these cases on behalf of the department. Okay.
A lot of the language today is that there is no wrongdoing. There's completely correct practice. It's a long-standing practice, which I have to say is different from it being a correct practice. So the department has stressed that it has broken no laws and finds no wrongdoing. Based on this, is it fair to assume that the practice continues as outlined to be employed by the department?
We're not saying here, Deputy, that there's something we can learn. Of course, there are issues we can learn here about sharing data, about management of data, other issues that deputies have been raised. Absolutely. And there's never any situation involving complex policy or legal questions where there's absolute certainty. There's always difficulties, there's always greyness, there's always trade-offs. So we're not suggesting that mistakes haven't been made. We're not suggesting that we do everything properly. But what I'm very clearly saying, though, and I hope there's no doubt about this, that the substantive allegations made against officials in the department by Prime Time, there is no basis for those allegations. The notion that there was a covert campaign to have secret dossiers, prying on families, of directly seeking reports from clinicians, private investigations, and so on, that it's very, very clear, I think, from the questioning from yourselves this morning, and from
Mr. Watt, if you don't mind, I probably only have 1 minute left. Could I just make the point? No, I'm speaking to what you're speaking to. Yeah. Can I just say that you've made that point a number of times today, and you've also said things like there's an implication here that something untoward was happening here, and it's absolutely not the case. With the greatest respect, until the Data Commissioner decides that, you can't possibly know that.
No, of course there could be issues in relation to data protection. Absolutely.
Those are legal issues. Data protection is also a legal issue. Of
course could be, Deputy. Absolutely. And there are the Data Commissioner is doing the review, and we're working with them on that. And there are issues about, but the legal advice we have and have had consistently is that our approach of sharing data between co-defendants in legal cases is consistent, is lawful. But of course, Deputy, absolutely, if that is the case, we'll put our hands up and say yes, we'll have to do better. But just to clarify this, because this gets to the centre of the concern the parents have and the allegations which undermine people's confidence in government departments like health and other departments. Prime Time didn't just allege that there might have been breaches of data protection, or that they made much more serious allegations than that. And that's what I'm just saying this morning, that it's very clear, based on all the work we've done over the last 2 months,
does the department make any differentiation between, as Deputy Shortall asked, between live or imminent cases and dormant cases in their approach to data collection?
No, I don't think there's a differentiation. No, I think cases are cases, and we try to, data is shared, information is shared on cases, and when we're trying to settle cases, obviously there might be an attempt to seek a service update to settle, as we've done since 2017. But I don't think, no, Deputy, there's a substantive difference, no.
Okay, so there's no cut-off point where a case is considered after 5 years, after 10 years, this is not going to be pursued. You continue to gather information.
Our legal advice is that within the Irish legislation is that once a case is open, it's open. The term dormant isn't actually a legal term, it just means that there has been no activity on that file for a period of time. So our advice has been that in order to be able to continue to case manage these cases, that service updates and information is required. And all of that is required. So even when a child ages out,
even when a child ages out, you continue?
That is our advice, that these files need to continue to be case managed until we can work towards a settlement or a conclusion of those cases.
You need to finish, Nessa.
Thanks, Chair. That's it.
Thank you. Gino Kenny.
Thanks, Chair, and thanks for Mr. Watt's statement.
Deputy.
And his colleagues today. I think, Mr. Watt, most people that watched the primetime investigations would have been quite kind of uneasy in relation to what they saw, and I think it was wholly unsatisfactory in relation to the findings of the programme, whether you agree or not. And nobody's ever said what the practice that was going on in the Department of Health was illegal, but was it ethically correct? And families that have and that still are bringing the state to court for the basics of needs, and the basics of needs is relation to special education needs. So they have to bring the state to court. Now, nobody could defend that. So trust and confidence is paramount, absolute paramount, right, in relation to this. Was there a breach of that trust and confidence in relation to the practices that was going on in the Department of Health?
So, thanks, Deputy, for the question. First of all, we were as uneasy and as appalled as anybody else, I'm sure, when we saw the programme. Officials in the department were as upset about what was said and the distress that may cause families, and the fact that the allegations were untrue. And I absolutely agree with you about if people believe, and unfortunately, if it is established, which it might be subsequently, that there's no validity behind these allegations, that'll be up to others to decide. If that is established, unfortunately, the damage will still be done, because people may not necessarily look back at what the final outcome to this is. They'll have watched the programme or heard the debate or heard the discussion about it. So, unfortunately, no matter what the outcome is, trust can be eroded. In terms of, so I think you're right, Deputy. No matter what happens, I think that's a regrettable outcome of this, and where responsibility lies for that, that's for others to decide also. But in terms of the question about cases that are taken, I think to reiterate the point here, in the vast majority of cases they don't go to court. I think we just have, two, we said, of the 230 had actually gone to court. Most of these are settled. So the situation is that they're settled. There's an issue, a wider issue, which I guess is the kernel of your question, which is a policy question about people taking cases against the state in order to improve access to services, and about the state's position about whether the state should contest those or accept them. And as we spoke about in response to earlier questions, in many cases, the evidence presented by the plaintiffs is such that the state will accept, will settle quickly, will not in reality contest the case. But there's a wider policy question about citizens have rights, and citizens have rights to have those rights vindicated legally and through the courts in Ireland. That's how our constitution, that's how our legal system works. So that's obviously, people have that right. And secondly, I don't think there's ever going to be a situation where we'll find that families are 100% satisfied with the services they receive. They're never going to be satisfied, I think. Or there's never going to be a situation where everybody will be satisfied all the time, because the nature of it. It's just, this is it's a contested space, it's a challenging space. We would like a situation where it never came to it, of course, that people took cases. We'd like a situation where the services provided were met to the satisfaction of all the families all the time, and that, but of course people sometimes don't believe that, and they want more, and they want better, and they have a right to challenge that. But from the state's perspective, though, and this gets to the absolute essence of the discussion, really, which is the big discussion. What is the role of the state here? Should the state not contest cases Now, if the state didn't contest cases, well then you would have the provision of services provided, not on the basis of laws passed in the Oireachtas and then administration of those laws by government departments. You'd have the provision of services and the prioritisation of service provision on the basis of who has access to the legal system, who has access to solicitors. And that's where you'd end up. So if government departments didn't challenge, or if we accepted whenever a service was deemed to be inadequate and we accepted the case, well then in effect you would have the system gummed up forever with legal challenges, and the basis upon which we actually administer schemes would fall down. It wouldn't be on the basis of need; it would be on the basis of who has access to legal representation. And I don't think anybody believes that course of action would be desirable.
I do understand the dimensions of that, but there was a fundamental breach of trust in relation to families in relation to this. Now, the question is, does this practice still continue in relation to the Department of Health, the Department of Education? That's one question. Just my last question, if you could answer that. But just another kind of supplementary question in relation to Alan Corr's statement last week. Now, obviously you officials were at that meeting. He said in the statement, which was quite concerning, and I'll paraphrase exactly what he said in the statement. He says, ministers and TDs should know that databases containing representations made to them by the public were searched across the government departments. What practice was he referred to? Because, you know, alarm bells start ringing when he stated that. So maybe you could comment on that. Was this a culture in the Department of Health in relation to TDs making representations on behalf of their constituents in relation to families to access and special needs education?
So yeah, Deputy. So, like, I'm not going to comment on further allocations that were made in a session where we weren't invited to participate. I don't think I'm not in a position to do that. Like, obviously, reps made by yourselves all the time on behalf of your constituents in relation to a variety of issues, and we respond to those reps as best we can, and that's a legitimate part of the system which we all respect, and that has value, and that's how the system works, and nobody in the Department of Health has an issue with that. We respond to thousands of reps every month on a whole variety of different issues, and that's part and parcel of what we do. I'm not going to comment on the allegations, Deputy, because I don't really understand exactly what's been said, and I don't think it's appropriate. On the question, the question you make about trust and about breach of trust, I hope by the time that the families have an opportunity to engage with us and engage the process and review the practices, I hope that they don't feel that any trust has been broken. I certainly, based on what I've seen, that I don't think the allegations are valid, and on that basis, then, if their trust is broken based on a belief in the primetime programme, well, then I don't think there's a basis for that trust to be breached. But I do absolutely appreciate people's concerns, and we've reached out to families and representatives to try address their concerns. And I hope, Deputy, at the end of this process, that families are in a better place when it comes to how the state acted properly in terms of trying to settle cases and trying to do this in a fair and proper manner. But look, that's obviously for families to decide ultimately at the end of this process. But I hope that is an outcome that we get.
Thank you.
Thank you, Gino. Bernard Durkin.
Chairman, I'll be as quick as I can. The Secretary General made contact with the RTE around the time after the broadcast. Did you warn RTE as to the consequences in the event of there being further development of the case of the statements made on the programme?
No, Deputy, I didn't warn them because it's not for me to issue warnings or to do anything like that. That's not what I do. But I did, as I said in response to earlier questions, I set out our concerns that the allegations were extremely serious and we take them very seriously, and that we didn't believe that the allegations had merit, and that certainly there wasn't sufficient evidence to justify them being broadcasted. I have to say, Deputy, that I regret now that we weren't more forceful in responding to RTE before the programme. I think colleagues probably shared that we should have been more forceful with them, because I really don't believe that the program can stand up. And obviously we're concerned about the impact it's had, and Deputy Kenny's earlier question about trust and the implications it had for trust. So we're worried about broadly. So, but there was no warnings giving. I set out, which I think is reasonable to set out on behalf of the Department of Health, that we didn't believe the allegations, and the information that we had to hand did not support what was been argued.
Did they stand over their position, or did they resile from that during the course of your conversation?
No, they did. Well, I don't want to get into the private conversation, but the conclusion was that the DG was obviously, the DG didn't do the programme. She wasn't the producer of the programme, and she committed to talking to the people involved. So there was no.
In the event of there being legal action in respect of that programme at a later stage, would you then disclose the nature of the private conversation?
Yeah. So look, I'm not. There's a private conversation, but basically what I've said to you is my recollection of that. I said that the allegations, 2 points I made, the allegations are very serious, and secondly that we didn't believe they were valid. They were the 2 points that by recollection, I made to the DG. Okay. Like it was a friendly enough conversation. It wasn't an aggressive. I was just saying, look, this is very serious, and I wanted to make sure that she heard from me, that D4 heard from me directly, that we were very disturbed about what was being proposed.
You acknowledge that there were issues around data protection from your earlier replies. Did you feel that those issues were sufficient to require a change of policy?
Yeah. So when the review took place last year, and the data issues around data access came up, so we put in place further safeguards, and we reminded staff of their obligations in relation to data protection and so on, and that's set out in the report. So the Acting Secretary General then, Dr. Colin Burke, took steps to remind staff again about data protection, and we put in place extra procedures, which you mentioned, in relation to passwording documents and ensuring that we put in extra safeguards. So, and we're very mindful of that. And as I said earlier, there's no 100% secure system, and we're always looking at this, and we will continue with the Data Commissioner to have conversations with them about what other protections we can put in place. I'm very mindful of that.
I note the position in relation to dormant cases and ongoing cases and so on and so forth. There are 29 cases still open and under for legal action. Of those, how long are they open? How long have they been in place? What?
They vary, Deputy, in longevity. Do we have data on that? Sorry, Kathleen.
I think in fairness, and obviously we can't talk about individual cases, they vary in terms of time, but they do go back to the 1990s, so they go back to nearly 30 years.
Right. Do you think that it is a good thing, good policy, to have cases outstanding for that length of time? Incidentally, I would have dealt with many cases during that period, in the 80s and in the 90s, and prior to that, actually. But the point about it is that if there are cases that are unresolved, there's a dispute between the authorities and the individual citizen. What efforts were made, or are being made, or are likely to be made to bring such matters to a conclusion at an earlier date? For obvious reasons for all concerned.
Yeah, no, Deputy, absolutely. We share that concern that the objective is to try close these cases and settle these cases and move on. And I absolutely agree with you that it's not satisfactory that remain there. And that was the motivation, particularly from 2017 with the service updates, was a genuine attempt to actually find out what the latest position is, and then to try settle based on the up-to-date position on people's satisfaction or otherwise with the services they were receiving. And that was the motivation. And I think it's very regrettable that motivation has been twisted in a way to suggest that something untoward was being done here by officials, where in actual fact they were trying to, as you say, close cases which had gone on for too long, and that it was in the interest of all parties that they be closed.
Thank you. Thank you, Bernard. Thank you.
Thank you.
Senator Annie Howie.
Hi, hello, how are you? Just pull up Sorry, something here. I won't go on. I know that there are people coming after me who wish to also get in. So
I can't hear you, Senator.
Sorry, can you hear me now?
Yep.
Yeah, sorry, I'll hold the microphone up here. So I suppose I want to say, like, the allegations that were made on the show, on the Primetime Investigation show, really were quite extraordinary. And I have to be honest, I think that the public, either those who watch that programme or indeed are watching this public session today, will really be struggling to marry how these allegations could have been made and for there to be no basis in truth in them, as you were saying here. There's no basis for those allegations. You said the fact those allegations were untrue, no validity behind these allegations. So I just want to put that. I think that people are really struggling to marry those two things together, and I think there's an enormous responsibility actually for these, if as you say, these allegations are untrue, that they do need to be comprehensively proven. So because I think the reputational damage that has been done is immense. And I think the reason this struck a chord is because no matter what way you slice this, there have been and continue to be vulnerable children who've been forced to take action against the state in order to get their basic educational needs met. So notwithstanding that the allegations that are possibly not valid, in your own words, Mr. Watts, there's indeed a larger issue at stake that vulnerable families and children have been mucked about under the watch of the Department of Health. So you say that this has been a long-standing practice, and I know a couple of people alluded to this, whether or not that is still a correct practice. Would you say that it's an ethical practice? Like, I mean, look, I'm not a lawyer. You know, the law has to do what the law has to do. But I mean, I think, as I've said, this struck a chord for a reason with people, and I think one of the reasons is the ethics behind it. Is this an ethical thing to have done? And then just my second question. And you said that these practices will continue to take place. And you mentioned that these cases often end in mediation. Surely the answer should be that these cases end in the families and vulnerable children getting what they actually are entitled to, which is access to an education. Like, what actions, you know, we talk about cases being outstanding and and what's going to be done to do that. But surely, based on the public response and the feeling in this, that the actual answer should be that no one should have to do this in the first place.
Thanks, Senator, for the questions. So, first of all, I agree with you that the allegations are extraordinary, and people will find it very difficult to marry the programme with, I think, the documentary evidence that we have published and we have prepared. I think that's for others to decide, and I think it has done reputational damage. You know, and we're trying to address that as best we can, but it's very hard to address that fully. Of course, the practices that are alleged aren't ethical, and they didn't take place, as I've set out. So clearly, if we are prying on families or having secret dossiers, that will be inappropriate. But that didn't take place. So I know you're not talking about those ethical practices. I think you're referring to whether sharing information is ethical, and secondly, whether actually challenging the case is ethical. So I think on the sharing of the information, I guess it's seen as an efficient way for co-defendants to actually try manage the cases efficiently and resolve and mediate and settle the cases. So it's based on administrative efficiency rather than having one part of the case in one part of the system and so on, because you could have education or HSE or ourselves involved. So it makes sense for the information to be shared so that we have one file on all the different elements here that are relevant to the case and potential settlement of the case. So, in terms of sharing the information from the administrative necessity and the legality, we're satisfied. Can we share that better and be more secure about it? Yes, of course, we're looking at that, and we accept you can always do better. I think the question really is about service access, and that is, I guess, then the key question here, that's what we're trying to do, is to improve services. That's what it's about all the time, to improve services so that families don't have to take cases, and that you know the system provides the best possible services, and that where it's possible families are happy or content, but at least accept that more has been done, or that they're getting the supports they can. So ultimately, that is the objective, and that's what we're about in the department. And I think there had been significant improvements over the last number of years, very significant investment taking place, and enhanced services for people with special education needs right across the area. But of course, we all know that we can do better, and that's really the objective. The wider ethical question about contesting cases, like I have nothing further to add to what I said in respect to Deputy Kenny, that there's a fundamental public policy question here about whether we want service to be allocated based on people's ability to access the law or based on administrative practice based on laws passed by the Oireachtas. This is a fundamental question which goes way beyond, I think, our discussions this morning, but it is absolutely central to how you actually manage areas like this which are contested, and there are many areas in public policy that are contested, and people have rights, and people can seek to have those rights vindicated in the courts, and that's the way things work.
Move on to Senator Francis Black.
Thanks very much. Ciarla, can you hear me okay?
Yes, we can.
Thanks very much. Just want to say thank you to all our witnesses for coming in today, and I'll try and keep it as short as I possibly can. According to the Irish Times, the internal review looked at 29 cases that are still underway, but not at the over 200 completed cases where the Minister for Health was named as a defendant taken against the state, including those around special needs. So I'm just wondering, why did the department not increase the scope of the review and investigation to include all cases taken against the state where the Minister for Health was named as a defendant? And is it possible that the allegations could be found in these cases?
Thanks, Senator. So the whistleblowers, the disclosure of the disclosure report and the disclosures by the whistleblower related to those cases. So that's where the allegations were made, that in effect that the issues that were raised related to those cases. So that's why the focus of the review was on those, to address, based on the report and the Primetime Investigates, that it did relate to those subset of cases. The amount of work to review those cases was substantial. Like, there's a lot of go through the reports and compile the report that we did, took a substantial undertaking, and we basically concluded the work up to that point because they were the cases that were subject to the whistleblowers' allegations. We don't believe in what we found or didn't find, Senator, that there's a justification for doing further reviews. We don't think that has merit. We don't think that the cost, the time involved will be justified, given that there is no, at this stage, prima facie evidence of practices that we believe to be inappropriate as portrayed by RTE. So clearly, if we had found that the practices were widespread in those cases, well, then that would be a different issue. We would have to then look clearly at other cases. But since we didn't find practices that were consistent with the nature of the allegations made, we've concluded the process at those cases.
Thank you. Okay, and my second question is, do you regret how the department handled the communications since the programme was broadcast? I mean, whilst you did make contact with RTE to stop the broadcast, there was no effort to notify the families in advance. And I just feel that there's a sense that the department hasn't really shown any empathy or understanding or tried to meaningfully reach out since the crisis began. So, what will you do to restore the trust of the autism community?
So, first of all, Senator, I didn't try to stop the broadcast. Okay, right. That wasn't my intention. I don't decide what RTE publish or not. Secondly, we did reach out to the families. So on the 1st of April, which was a week after the programme was on the 23rd of March, I think, on the 1st of a week afterwards, we had written to the legal representatives of the families, we had written to stakeholders, and we had appointed a independent liaison officer. So we had been very proactive in responding. Now, Senator, you could always say we should have been faster or should have been more proactive. Look, I accept that, but I think we were fairly speedy, and actually our first concern was to establish the facts and to try reassure the families. That's what we were trying to do, and we did, I think, do that fairly speedily after the programme came out. But look, you can argue we should have done better, but I think we did do our best to try address the concerns that people have.
I'm just wondering, would you welcome an independent investigation to look at the issue as a whole? Like, do you think that might restore public confidence and should it be something which a department which insists has kind of that? Would you look at this as kind of a way of acting legally without fear, if you know what I mean? If that makes sense.
So I don't think there's any prima facie basis for an independent inquiry now. But that's not for me to judge. That's for others. If all committees want to investigate, that's their business. But based on evidence that we have, now if others have other evidence that they want to bring to bear, that might change it. Something else. But based on what I've seen, I don't see the basis for it under the various statutes that are there. I think you have to get to a certain level. Threshold. But anyway, that's not for me to decide. I think Kathleen wants to come in. Kathleen?
It might be just worth mentioning that the Data Protection Commissioner is conducting an inquiry, which we have welcomed, and we will be fully cooperating with them. We will obviously welcome any recommendations that the Data Protection Commissioner makes, and we will look to seek to implement any recommendations or any actions that come from them. And that is an inquiry that is in process at the minute, and that's a statutory inquiry.
And sorry, Senator, I might just add that as well. Obviously, the senior counsel's report, and that was an independent senior counsel that was brought in to have a look at the allegations in the first instance. So that was an external person who had a look through all of the allegations and the documentation that was presented to that person by the disclosure. So that independent eye has already been cast, I suppose, as well, to a degree. So between that and the DPC inquiry, I think that provides a level of external, I suppose, assurance that external bodies are having a look at this issue.
Thank you, Cathaoirleach.
Thank you, Senator.
Colin Burke is next.
Thank you very much, and thank you to the witnesses for coming here this morning. Can I just deal with the issue? And I'm coming from a background where I would have been involved in litigation against the Department of Health in a legal capacity, so I would be very much familiar with what's involved. Can I just ask in relation to discovery of documents, where there are a number of government agencies, including the HSE, the Department and the Department of Education, what is the rule as regards legal representation? Is it one set of legal representatives, or would there be a number of sets of legal representatives?
I think in terms of the plaintiff side, I think it tends to be one.
But on the defendant side, which would be the Department of Education, Health...
The Chief State Solicitor's Office. Chief State Solicitor's Office, in effect, is the legal representative for the departments.
And at what stage then, in relation to gathering of documentation for a case, where would the decision be taken as regards which body or which department would, I suppose, be in the front line for getting all of the documentation together? Would there be a decision taken on that?
Maybe let Kathleen come in on that. Kathleen?
Just the litigation is obviously directed through the Chief State Solicitor's Office. So the Department of Education and the Department of Health tend to be jointly represented by the CSSO in these cases, and I suppose the full documentation is obviously maintained by the CSSO, but the Department of Health and the Department of Education would retain documentation in relation to the litigation cases as advised.
Would there be coordination between the departments and, say, the HSE, and that one department would try and coordinate that, or would it be left to the Chief State Solicitor's Office?
Where the HSE would be involved, the department would obviously be coordinating with the HSE, and there are arrangements to coordinate with the HSE in relation to litigation and legal cases that are taken.
And just in relation to discovery, you might explain to us, where discovery is made, what's the extent of that? Would that discovery involve? What kind of documents would have to be made available on discovery?
Maybe our legal advisor here might be able to advise on that, but I would assume that anything that is sought we would have to process in relation to that discovery.
So the normal practice would be that information that's sought would have to be provided as part of discovery in a case. I'm not an expert, and we can come back on if there are exemptions, but in the main the documents would have to be made available.
But can you give us an idea of what documents would have to be discovered? Are you going back 3 years, 5 years, 10 years, 15 years? What would be the norm?
It would depend on the nature of the case, but the documents could be going back over a period, so there would be information provided by the plaintiffs in the main. So they would have access to that and any assessment that would have been done.
When Mr. Carr was in with us, he more or less indicated to us that the department officials were very worried about discovery and about getting documents, I suppose, getting all their ducks in a row in relation to files. Why would there be such a worry by department officials in relation to the discovery issue?
Yeah, I'm not going to comment on what the whistleblower said in a private session. I don't think it'd be fair for me to comment on that because I don't know the basis for it. But I don't think officials are always concerned the file is kept in good order, and if discoveries are made, the information is provided. But that's I don't wish to get into.
But in preparing,
Kathleen wants to come in. Sorry, Kathleen, do you want to?
I think it's fair to say that across all areas in the department, discovery is made, and depending on the order of discovery, the department will always cooperate with that order of discovery, regardless of whether it's these litigation files or other files in relation to discovery.
But
last question, Colin.
Is it a case that when proceedings start, that the State Solicitor would advise the department that they should take it for granted that an order for discovery will at some stage be made in this case? And therefore the department would have to be prepared at all times for such an order for discovery.
Yeah, I guess that I don't know, but I presume there was always that possibility. So files would be prepared with the possibility that the information would have to be given to the plaintiffs. Yes, like it's not unusual, as you know, in legal cases, obviously, for that to happen.
And finally,
Colin, you've gone over time.
Has it arisen where the department have been reprimanded for not producing all the documents of discovery?
That's what I'm aware of now.
Thank you. I need to move on to Lorraine Clifford-Lee.
Thank you very much, Cathaoirleach, and thank you to the witnesses for coming before us and answering the questions posed by my colleagues. If I could, perhaps, Mr. Watt, just move off this topic very briefly, and I just want to touch on something else and just ask for a clarification from you, Mr. Watt, in relation to women travelling for abortion services in the United Kingdom, if they're considered urgent medical service under the COVID-19 travel regulations. And I ask this question because the abortion service
I think we're moving off
network,
the subject matter this morning. You can maybe take the question.
If he could just clarify that, because I'm sure it's something that he has come across, because a number of queries have gone in, I believe, to the department. So if you could just confirm that if it is considered an urgent medical service. That's all, my only question here today.
Thanks, Senator. So when I return to the office, I'll communicate with your office about that.
Thank you very much.
That's okay.
Okay. Could you just give a yes or no answer to that?
I'll come back to you.
I think it's inappropriate. So anyway, we're moving off the subject matter here this morning. You can put down a parliamentary question or put it through the minister.
Question. I just thought with Mr. Watt before us that he could just say yes or no if it is actual essential service, and if women would have to provide a PCR test.
Okay,
I don't want to give any incorrect information to you, so I'll check and come back to you. Okay.
Okay. Thank you.
Sean Coyne.
Good morning, Secretary General, and you're welcome, and congratulations on your role. Just a couple of questions, and I know that we touched on it earlier in relation to your opening statement. And I'm just intrigued with your choice of theology where you say on the 7th link on page 3, use the phrase, there is no evidence. You don't say the department haven't or are or whatever, you say that there is no evidence. There's no evidence that the Department of Health was seeking to compile these dossiers. You don't say the department were not compiling dossiers. Can you just explain that? Is that legal advice, or I'm just intrigued by it?
No, it's not. It's just the way it was written.
So there's no legal advice to phrase it that way?
Don't think so, no.
It's also in the report that was commissioned within your department. Again, there is no evidence. I just find that strange, where rather than denying something or say something is not happening or whatever, you would use that term or phrase.
So instead of saying it didn't happen, saying, yeah, so I guess we want to be very clear, like we did a review So the senior counsel did a review, and then we did a review then with the help of further counsel, evidential barristers, and they found no evidence. So obviously it was our view on seeing the programme that we didn't believe those practices took place. That was our firm view that we reached on seeing the programme. We didn't believe that, but all of the pieces of information that comprised the disclosure to Conor Brady contain elements which led to the whistleblower's conclusion and RTE broadcasting a certain conclusion. But the independent counsel doesn't believe that those conclusions are valid, and nor do we, based on the further work that we've done. So it's sort of saying that there's no. So if somebody's making an allegation, they have to have evidence to support it, particularly if it's a serious nature and if it's a matter of public interest. And what we're saying very clearly is that there is no evidence to back up those allegations.
Okay.
I don't know if it could, in either way, it's not necessarily legalistic. I guess it's just to try to set out that based on what we've looked at, there's no evidence to support it.
Okay, thank you. In your previous role as Secretary General for the Department of Public Expenditure, I'm sure you would have met with or discussed or liaised with Department of Health and Education officials and Secretary Generals regarding legal cases. I'm just wondering, the disclosure as outlined by Mr. Bradley in his report stated that one of the bundle of cases was estimated to have liabilities of up to €7 billion. Now, unless that's a misprint, it's an astounding amount of money. Can you confirm, would you have been aware of that in your previous role? I'd imagine you would, in terms of a guardian of the Exchequer finances, if you like. Would you have discussed such cases with department officials?
I'm not aware that there's a liability of $7 billion outstanding in respect of legal cases.
Well, it's outlined in Mr. Connett's report. Again, unless it's a misprint, I found
that's
amount of money.
Let me just check. I can find the exact reference. This is in relation to supposed liabilities.
Yes.
Yeah, this is based on what the disclosure alleged, but that's not. That contention wasn't supported by the report. I'm just trying to find the.
Is it clarified? I haven't been able to see clarification of it.
You check now. Yeah, thank you very much.
Case, or?
So this, yeah. Yeah. So the disclosure stated that most of these bundles involved the most vulnerable needy people in the state, and the object was to keep those people, the government and the Dáil, as well as the citizens, for accountability in the dark. The disclosure stated that these bundles, which I guess refers to legal cases, one was estimated to have liabilities of up to $7 billion. So I don't think there was any information that supported that allegation. Certainly, the senior counsel, in his conclusions, didn't state that there was evidence purporting to support that.
Okay, this is back to the evidence. Do you have a value on possible liabilities to the department? Because I can see, from the point of view of the state, that those will be important issues. So just in your previous role and your present role, do you have an estimated liability?
Yeah, we do. The State Claims Agency, so most of the cases taken against the state were involved significant liabilities relating to medical negligence, and the State Claims Agency manages those on behalf of the state. Now we're getting into an area which isn't covered by today's proceedings, but the costs of this per year are about 400 million. So the outstanding liability, the net present value, as it were, of likely liabilities basis on settlement of cases, the normal settlement or costs, goes into billions. And I think there is a number produced in the finance accounts that the Department of Finance produces every year of the contingent liability associated with those cases. And I think I'm trying to remember, I think it's 3-4 billion, but I could be mistaken, that type of number of cases. But they don't relate to they don't necessarily relate to these cases. Obviously, these are a small subset, and the type of settlements are very different. Obviously, we're talking about clinical negligence, serious negligence cases where settlements might run to millions. But there is a liability. There is a figure that is included in the finance accounts every year. We'll come back to you on it. I don't have it, but I think it's of that order. It's 3 or 4 billion.
You
I
have
think it's
to
accrued
finish.
estimated liability.
From your experience in your previous role, are there changes that you will be proposing to be made regarding these cases going into the future in terms of protecting the exchequer, but also, in your new role as Secretary General of the Department of Health? Are there changes that you will be envisaging?
So I think there's obviously these cases we're talking about this morning aren't covered by the State Claims Agency, but there is a wider issue about obviously medical negligence and cases taken against the case, which involve a whole variety of issues around patient safety and patient care and clinical pathways, and how we establish harm and fault and negligence and damages, all those various issues. There's a report. Now I'm getting into an area that we're not to cover this morning, but anyway, the Meehan report has set out a variety of recommendations, and the department is looking at those with our colleagues in Justice and elsewhere. And I think there is certainly measures that over time we hope to take to reduce the number of cases and to improve how we manage those cases to reduce the liability for the taxpayer, because it is a very, very significant cost. The cost of the State Claims Agency every year is going up. I think 10 years ago it would have been 200 million, and now it's over 400 million a year. So the cost of these cases are mounting, and it is a big challenge for the state.
Okay, I need to bring in just Cathal Crowe just for a couple of minutes. Cathal, we've run out of time.
Thanks, Chairman. Just to thank Mr. Watt and wish him well in his new role. Just a few quick questions, if I can. I've read your opening statement, and I think it's on the second page. You take up this whole issue with your correspondence with RT after the programme aired. I would just like to know what contact did the Department of Health have with the investigation unit in RT and with D. Forbes in advance of this going to air, because your opening statement has 5 or 6 bullet points which absolutely refute what was aired and shown to the whole nation, but it seems incredible that these points weren't all put to RTE beforehand, that the programme actually went to air. The next question I wish to ask, I'll bundle them together if that's okay. Obviously there's 29 court cases pending, but there's a lot more in a backlog that have now been dealt with. I'm sure you've been overwhelmed with freedom of information requests since this went to air. Have the department on foot this? Has your data protection officers, your freedom of information officers, to what extent have they any percentages as to how much of the files they've had to redact when freedom of information was issued to people? And then finally, just Chairman, I wish to state that all of this, when we bring this all down, when you get beyond the lofty levels of litigation and Department of Health defending themselves and setting out their stall, at the hub of all of this, we have children with special education needs and their families. And as last contributor today, I wish to conclude by speaking on this. I was a teacher for 16 years before entering the Dáil. The fact remains there are still many unmet needs for children and teenagers with special needs. And I would ask that as Secretary General taking on this role in the department, you would look at one of the huge anomalies. We have special education needs organisers from the Department of Health side. We have CAMS at the Department of Health side. There's a lot of disparities and things not adding up. And the reality is, over the past 14 months of COVID, many, I should say, I wouldn't say most of, but many of the supports laid on by the Department of Health, such as CAMS, haven't been fully up and running. They haven't met virtually. They haven't met the needs of children during this period. And I think that also needs to be looked at. Yeah. It isn't all about litigation. Thank you.
Yeah, no, look, I agree absolutely with those sentiments, and that's the focus is to improve services, and there are many gaps, as you say, and I think the situation has been difficult for a lot of people over the last 16 months or so, and particularly challenging for people in dealing with COVID and all the restrictions. So, but I absolutely agree with you that the key point here isn't about litigation or isn't about Primetime Investigates. It's about the ability of the system to use resources and to get more resources and galvanise supports to help people, and that's absolutely the focus of the Department of Health and our colleagues here are with me today who spend a lot of their time, their careers on these issues. That's really their focus, to improve services, and that's definitely my motivation and the motivation of colleagues in the department. That's what we're about, and Minister Donnelly and the Taoiseach and the government. That's the absolute priority. In relation to the other points you mentioned, so there's correspondence that we had with RT, and I think we've published that the letters. We can make those available. I think to the Dáil, the correspondence between us and RT in advance of the programme, we can make those available if we haven't already. I think we can do that. In terms of FOI, there are an awful lot of FOI requests coming in. Obviously, the information is personal information in the main, so it's not given out generally. But of course, the data requests from the families or the representatives, the department, as I mentioned earlier, is doing all we can to assure the families in respect to the allegations that were made. So we're working on that. But there's a very significant work ongoing now in terms of trying to support families and to work with families on foot of the concerns they have.
Okay, thanks very much. Can I thank Mr. Watts and your colleagues for...
Just to conclude, Chairman, by the FOI officer should be able to quantify the percentage that have been redacted.
Sorry. Yeah, apologies. Yeah, on that point. Yeah, it's again, it can be a little bit subjective what the percentage, but yeah, we can look at that. It depends on the nature of the FOI, what the FOI is. Obviously, for personal information, the FOI wouldn't recover personal information. Unless it was from the individual, of course, who's concerned. But a general
percentages only would be good. Thank you.
We'll have a look to see. Yeah, I understand the point. Sorry about that.
It's been a long morning. Thank you, Mr. Watt, and your colleagues for your answers here this morning. I think you're right when you're saying that confidence has been undermined, and your point about citizens have rights, and unfortunately, many citizens feel they're forced that they have to go to the courts to get support. I know of cases that people waiting over 2.5 years for an assessment, and then possibly waiting another 2.5 years for support. So unfortunately, that's some of the reasons why many people feel that they have to go to the court. So I really thank you for your answers here this morning. I think it's helped the committee in its deliberation. That concludes our business for today. The meeting now stands adjourned until 9:30 a.m. next Wednesday, the 12th.